Hello there, how are you? In this video, we are going to talk about some of the common legal questions that are asked by creators in the NFT space. Now please note, this video is not legal advice. In any case, you would prefer to go to a professional lawyer if you have any legal questions. Nevertheless, this video can be useful to you if you are trying to get into the NFT space as a creator or as a buyer or as a collector. So without further ado, let's get started. The first and the most important question is how does copyright law apply to NFT art? NFTs do not change the operation of copyright. The underlying work is protected by copyright, which can be retained by the author or transferred to the holder of the NFT. This is similar to how a copyright in a conventional piece of art may be transferred to a third party. That being said, copyright transfer must be in writing. Whether a smart contract is writing for purposes of the Copyright Act is not a settled legal issue. So something to keep in mind, that smart contract is not going to be the legal document that can settle the issues with the copyright transfer. You need to follow an existing traditional process in order to set up the copyright transfer document. The next one, if the sales platform mints an NFT of digital art, does the smart contract need to specify who owns the copyright? Straight answer is yes. The next one, if a platform wanted to display an NFT image for public viewing, would the platform need the permission of the copyright holder, the owner of the NFT, or both? The answer to this will depend upon the terms associated with the NFT. A typical allocation of rights would be that the platform would need the permission of the copyright holder in the underlying work and not the permission of the owner of the NFT. But that allocation could change with the terms of the NFT. An artist could license the artist's rights to a work exclusively to the NFT owner, which would require the platform to obtain the owner's approval in order to display the work. So these were some of the questions related to copyright. Now let's talk about some of the legal questions related to NFT minting. So the question is, what are the risks of NFT minting? Well, the answer might depend on who is minting the NFT. The creator could mint the wrong NFT or could input the wrong content or omit information and not be able to change any of this afterwards. If a platform is transferring an NFT that has already been minted, there could be risks associated with the transfer like hacking, theft, counterfeiting, etc. If the platform creates its own blockchain and mints NFTs to that blockchain, there could be technical or structural risks. So these were some of the risks associated with minting NFTs in different ways. The next question, if the platform mints the NFT art, will the art appear as having been generated by the artist, the platform, or both? The answer to this requires scrutiny of the smart contract deployed to mint the NFT. Typically, most marketplaces will require that the participants mint only original content or content in which the participant has rights. If you're minting another's work, the participant could add information about the artist. Now let's answer some of the questions about smart contracts. So what is a smart contract? A smart contract is a computer protocol that digitally facilitates, verifies, and/or executes the performance of a contract protocol. The question is, can a sales platform add terms to the NFT that govern how the sale will be conducted on the platform? Yes. It is common and recommended to impose terms applicable to the NFT purchase to affirm the legal enforceability of the protocol in the smart contract. The next question, how would a smart contract handle a not yet determined sales price? Smart contracts define rules and automatically enforce the rules through their deployment. As long as the rules are programmed into the protocol and the smart contract ingests accurate data, the smart contract deployment will produce a certified output. Smart contracts also can be crafted to communicate with other smart contracts, which may increase the output possibilities. The platform's product development team should work with commercial lawyers versed in blockchain technology to ensure that their smart contracts align with the parties' legal commitments. Now let's talk about some of the questions associated with the transfer of the NFT. If the sales platform does not mint the NFT, or if after minting the NFT is not transferred to the platform, how can the platform be sure that title will transfer to the buyer? The answer is, an NFT will not transfer payment to the seller until title to the NFT is transferred to the buyer on the blockchain. Does the platform need to take title in order to transfer possession? No. As in the case of physical goods, the platform can conduct the sale process, notify the seller and the winner of the result of that process, and the seller can transfer the NFT to the buyer. The platform does, however, need to have the contractual ability to force the seller to fulfill its obligation to transfer possession. A lot of people ask this question. One reason why a sales platform takes possession of physical art is to make sure that the seller doesn't sell it to someone else. Is there a way to do this without taking title to the NFT? The answer is, an NFT can have only one owner at a time. So the only way to be sure of avoiding the classic double spending risk is to own the NFT. That said, there may be other better ways to achieve this goal. Example, by contract with the seller or use of escrow accounts to guarantee transfer by the seller. Escrow accounts is a common feature of WazirX. If you are looking to mint your first NFT, you should definitely try the WazirX NFT marketplace. There is a playlist linked below in the description as well as at the top right corner that should give you a broader discussion of what is NFT and how to mint your first NFT. Now, moving on to the next question. This is related to your anti-money laundering laws. What are the anti-money laundering laws and related issues that pertain to NFT sales? The Global Financial Action Task Force published guidance in March 2021 that has an impact on decentralized finance markets and NFTs that should be considered. Some of the key AML considerations for a platform relate to enhanced regulations in the US, the EU, and the UK that expand AML requirements to dealers in art. In addition, the platform should be considering the application of such regulations to crypto assets, exchange providers, and wallet providers. Under these enhanced regulations, activity involving exchange, security, and utility tokens are brought within the AML rules. From a regulatory standpoint, this may include obtaining appropriate registrations and making required disclosures and interfacing with the applicable financial intelligence units. From a compliance standpoint, this may include the development of policies and procedures, including Know Your Transaction and Know Your Customer procedures, risk assessments, training, suspicious activity, investigating, and reporting. As noted above, it is possible in some circumstances to avoid these sorts of obligations by partnering with an entity that has all the correct licenses and does all the necessary checking. Now, there is one more question that is often asked. Can the identity of a buyer of an NFT on the blockchain be kept confidential? There is no reason why a seller or a buyer cannot maintain the confidentiality of his or her identity, but so far, most NFT marketplaces maintain the right to require an entity to prove its ultimate identity even while permitting the entity to transact business confidentially on the platform. So essentially, you can be without identity when you're transacting on the platform, but the marketplaces, to be on the safe side, will want to know your identity. How should the platform address artist-imposed future resale royalties in its sales agreements and conditions of sale? NFTs that provide for future resale royalties will automatically pay out future resale royalties to their creators when they are sold. Royalty systems differ for each marketplace, so this issue needs to be reviewed on a marketplace by marketplace basis. Does the platform need to get involved in the collection of these royalties or enforcement of the terms? No, it's automatically handled by the blockchain. Some of the perks of living in the technology of cryptocurrencies. Now let's answer some of the questions related to sale cancellation. The first one, can the NFT be corrupted? This is not a legal question, this is a computer engineering question. Nevertheless, the uniqueness of each NFT is said to be incorruptible, but again, we counsel caution. What are the mechanics of NFT sale cancellation? To delete an NFT, one would burn it to remove it from the blockchain, but this would remove the NFT entirely. If a sale were to be cancelled while preserving the existence of the NFT, This is primarily an issue to be dealt with in the terms of contract. Another question that is commonly asked: if a buyer pays a USD purchase price in ETH and if the sale is cancelled 3 years later, and if ETH has become worthless, how will participants account for the change in value? We would draft the contracts such that the seller would be obligated to return the sale proceeds in the fiat currency of the relevant sales jurisdiction in an amount determined by using the exchange rate prevailing at the time of sale. Now we will end this video by answering one last question about insurance. What role does insurance play with respect to the sale of NFTs? Insurance coverage opportunities for NFTs will develop over time, but it will be bespoke coverage or no coverage near future, something to keep in mind. Now with that, we hope we answered a lot of these questions in the most accurate manner possible. Let us know in the comments if you have any other questions. Like, share and subscribe. Thanks for watching. Have a great day.